Hypocrisy.
Hey, what's up, guys? Welcome to Lawsplaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. How is it going, guys? Look, I am not going to belabor the intro tonight because I have about an hour to 90 minutes to do the show. So I'm not going to sit and ramble like I normally do. If you are a person who counts on me rambling, too bad. You're going to have to go back and watch the beginning. It's just how the night is working out. Life is funny that way, but we're going to get into this. 2 minutes late. I was on time. The hell's wrong with y'all? Here we go. We're going to get right into this. We have Trump updates. Trumpdates is what I'm calling them now, which is a terrible name, but hey, it works and it's less characters. So we're going to talk about that. And I think people should get used to that for at least the early parts, probably most of 2024, because Trump is going to be major news. His legal issues are going to be major news constantly throughout at least the first half, if not all of the year, as we get into election season. That's just not going to go away. These legal challenges aren't going away. And he is the chief executive in some rather unique legal situations. And it's literally going to be making new law around Article 2 of the Constitution as the courts start to hammer this out. And if we're not here to cover new law around the Constitution, I don't know what we're here for other than raunchy jokes, general racism, and probably too much liquor. That being said, as announced earlier, as announced the past couple shows, January is Sober Stream Month. There will be no liquor consumed on the show for the month of January. And I've already been accused of cheating at it, which is great. It definitely did, and will continue to do so by drinking Monster Energy drinks, Gatorades, Propel, whatever else I can fucking drink, since there's no alcohol and I need an emotional habitual crutch. But yeah, so that's going to be a theme for January as well. We'll see how the show goes with no liquor. And then we'll see what we do for February and on. Maybe it sticks around. Maybe it becomes like a partial feature. I don't know. We'll see. We'll see what happens. You see what happens, Larry? Do you see what happens? Anyway, that will be the theme going forward. Other than that, we will hit a couple super chats that have come in, and then we will get directly into, the Trumpdate on legal issues. And then the other main topic of the night is Texas is banning emergency abortions, which kind of shocks some people. The interesting thing about this is people are appalled, I guess, at the idea that a state can say, yeah, even in this circumstance, we're still not going to allow abortions, which bothers some people. But we're going to talk about it. We're going to talk about if they can do that, what is going on with it, all of that stuff. So we're going to just keep going through that issue, and we may have to hit it more, but there's a pretty big ruling on it that just came out. So we're going to check that out. All right. Lord of the Ree is now a monthly supporter on Rumble. Thank you very much for that. Oh, yeah. This show will not have a Rumble flip in it at all. We will be doing the whole show on Rumble and YouTube because, again, it's going to be 60 to 90 minutes depending on how the topics go. But we're not going to be really having enough time to do that flip. We should have a normal stream tomorrow. I know we were supposed to have a normal stream today, but hey, life is as life does. Why Texas? Are you saying why Texas or why Texas? We'll figure it out. Horror Story Reading says, while it is true, Nick did confess his love for a dude, but let's not forget Legal Mindset was a huge simp for Mandy too. Well, yeah, Guys, I told you I'm gay. How many times? He also says, I'm not saying Mandy is a dude or not. Well, why? But just wondering, does Nick's wife like it even more now knowing Mandy could be a dude and her husband would save it? I don't know. I'll have to ask her. We'll figure that out. Just for you, brother. But yeah, I don't know why people are confused by this. All right. Let's get into this topic. Again, like yesterday, I'll just tackle any super chats that come in as we go. That way I'll be better able to manage the time, especially on stream tonight, since I am time limited. We'll keep that in mind. All right, first topic here. All right, here's a fun headline that is not the most useful, but we'll check it out. This is from the Daily Beast, which is fantastic. Here we go. The judge drops most, but not all, counts in Trump's January 6th civil case. Now, if you have kept track of all of the different cases against Donald Trump and are intimately familiar with their details, you are probably autistic. There are so many different cases against him or cases that he's included in. This is merely one of them, which is a civil suit from some people involved in January 6th, and they're suing Donald Trump for a couple different things. 5 of these charges, so to speak, counts, whatever, have been dropped, and we're going to talk about what they are, what's remaining, and that's a pretty big update because, I would say there's a propensity to overcharge in general. In civil cases, you shoot for the moon, and then judges will often shut things down in the middle of it. Traveler says, you catch the news that Japan got sick of the woke crap and is going to start suing AI voice acting. Oi, Jamie's politics may end up knocking down the American VA crowd. Old Jamie's politics. Who's Jamie? I have no idea what that is. No, I didn't hear that news. The only thing I heard about Japan is that an earthquake hit it, and then like a tidal wave was going to hit it again. Who knows? I don't know. That weird little crescent-shaped island is full of anime and leftover radiation. Here we go. The move is likely a win for Trump and his fellow defendants. Likely? Yeah. Well, you have 5 counts and 3 of them are dropped. Well, it's likely a win, though the lawsuit will soon move forward with the core allegations on which it was filed. Oh, okay, sure. A U.S. District Court judge on Tuesday dismissed most of the civil counts against former President Donald Trump and several others for their alleged role in the death of U.S. Capitol Police Officer Brian Sicknick, who died while defending the Capitol on January 6, 2021. Now, if you want to see the definition of retarded lawsuits. Oh, Jamie Markey. Sorry, I'm bouncing back because someone said Jamie Markey in the chat. Yeah, okay, that makes more sense. I forgot she existed, which is weird. She must be behind the sun right now. Don't feel the gravity the same way. But yeah, Brian Sicknick apparently died while defending the Capitol, which I don't think that's even true. Didn't he die like later from a heart attack and not at all while defending the Capitol? I thought that was the case, but maybe I'm wrong. Anyway, if you want to see, like, Trump obviously has nothing to do with this guy's death. Literally, even if you come to the conclusion that he died defending the Capitol and some January 6th rioter was somehow responsible for it, then you still have trouble getting to the conclusion that Donald Trump is liable for the death. He died a few days later. Jesus. 8 hours after it was over. 3 days later. Unrelated stroke. 3 days later. Stroke a day later. It's I don't know what the answer is, but clearly it's not at the moment. Destiny's looking for a law debater regarding the Trump, Georgia, and federal indictments. It'd be cool to see you guys debate. I mean, I haven't been around during the day to do so. I'll reach out to Destiny and see when. I know he's got like a January 6th thing coming up, so I'll see, which means he probably wants to do something this week. I'll see what I can do. I'll reach out to him because I find talking to Destiny interesting. We disagree on a bunch of stuff, but he's not generally, well, when I've talked to him, he hasn't generally been an asshole, so he's not an uncomfortable person to talk to. All right, here we go. Sicknick's partner, Sandra Garraza, filed the lawsuit last January alleging wrongful death, conspiracy to violate rights, 2 counts of negligence under an anti-riot law in Washington, D.C., and a claim under the D.C. Survival Act. Now, when they say Sicknick's partner, Sandra Garraza, who the fuck is that? Like a wife partner? Sandra Garraza. Is she Brian Sicknick? Or is she like, because when I hear partner from a capital, what? Who won't admit my partner. Wait. Oh, okay. They were like married or something, sort of longtime partner. When I hear partner in relation to law enforcement, I immediately think like partner, right? Like RoboCop and that blonde chick or whatever. So, okay. So that makes, because I'm like, why the fuck does his police partner have any? Okay, never mind. I don't pay attention to these people. Alleging wrongful death, conspiracy to violate civil rights, 2 counts of negligence under an anti-riot law in Washington, D.C., and a claim under the D.C. Survival Act. But on Tuesday, U.S. District Judge Amit Mehta, an appointee of former President Barack Obama, who has, I believe this is the guy who has delivered several negative rulings for Trump, dismissed 3 out of the 5 counts, leaving only the conspiracy to violate civil rights charge and the D.C. Survival Act claim. So now we have this great, well, they can't decide between charges, counts, and claims, but we have this conspiracy to violate civil rights. Well, where's the violation of the civil rights? I guess his right to live. Trump's involved in a conspiracy to violate the civil rights, but there isn't an actual violation of civil rights claim to go with it, just the conspiracy claim. And this is a weird product, I guess, of how the law works, where you can have a conspiracy and just allege a co-conspirator, right? You just allege that a co-conspirator exists, even though you never have to name them or actually bring conspiracy or bring the actual charges to the other person. So this is just a fantastic way to slip in this thing where he's like, Trump conspired with unknown persons to bring about the deprivation of civil rights of Brian Sicknick, which is one of the dumbest things ever, because how do you, so conspiracy involves, an effort of some sort to do the thing. So deprivation of civil rights tends to require an act to deprive the civil rights, and the conspiracy would require steps towards the act. You almost have to have some sort of intention to do so. How would they know? Like, how would Trump know that this guy was going to die later is the ultimate question. That'll be the question, I guess, at the jury trial if this thing goes on. But again, this to me still reeks of a civil immunity defense. We'll have to see if he raises it. The move is likely a win for Trump and his fellow defendants. No, it definitely is. Having charges dropped is always a win, or counts or claims. Though the lawsuit will still move forward with the core allegations on which it was filed. Sicknick was killed in the January 6th attack after rioter Julian Cater sprayed him with a chemical spray from less than 8 feet away, causing Sicknick to collapse. All right. All right. A chemical spray, it's a pepper spray, less than 8 feet away, which happens all the time. All the time. Pepper spray is deployed less than 8 feet away. But let's see if we can find out anything about this Brian Sicknick guy and his death. Where do we go? Death of Brian Sicknick. On January 7th, 2021, U.S. Capitol Police Officer Brian Sicknick died after suffering 2 strokes the day after he responded to an attack on the U.S. Capitol. D.C. Chief Medical Examiner found that Sicknick died from stroke, classifying his death as natural, and additionally commented that all that transpired played a role in his condition. All that transpired. Okay. His Cremated remains were laid in honor in the Capitol Rotunda on February 2nd, before they were buried with full honors at Arlington National Cemetery. Multiple media outlets reported Sicknick's death was due to injuries he sustained, but months later, the Washington, D.C. Medical Examiner reported there were no injuries to Sicknick. Within a day after his death, the U.S. Capitol Police and U.S. Department of Justice each said that his death was due to injuries from the attack. Meanwhile, media, citing two anonymous law enforcement officials, incorrectly reported for weeks that Sicknick had died after being struck in the head with a fire extinguisher during the unrest. So we have this death. After being in the hospital for almost a day, Sicknick died around 9:30 p.m. on January 7th. Earlier that day, he had 2 strokes. The strokes were due to basilar artery blood clot, which caused damage to his brainstem and cerebellum. His family had been informed that he was treated for a stroke caused by a blood clot and had been surviving on a ventilator. So that is, I don't know if anybody knows this, but a blood clot does not occur from a fucking pepper spraying. It doesn't happen from a pepper spray. So I want to see them tie this to that. They're going to say, like, maybe you go, oh, well, it's a stress-induced stroke or, some sort of trauma. No, like, you got a blood clot, brother. How the fuck are you going to go ahead and attach that to a pepper spraying? It's impossible. But who knows? I mean, you don't have to have the truth. It's a civil suit. You're protected from, just lying about it. The District of Columbia's chief medical examiner said he died of natural causes, but that all that transpired on January 6th played a role in his condition, which led to his death, which is, of course, ludicrous. The entire thing is ludicrous. I don't know what else to say about it. You can see this shit happening, though. This is just the general concept that Donald Trump is responsible for everything somehow. But let's figure out where the conspiracy comes in. Who's the co-conspirator? The guy who pepper sprayed it? So Trump worked in collusive agreement with a pepper sprayer to pepper spray Brian Sicknick and deprive him of his civil rights? Okay. I guess that makes sense. Sure. Is there any evidence of this? I mean, the big defense here is obviously that you go, yeah, he died of natural causes. And they'll say, well, he died of everything from January 6th. Like all of the events of January 6th, none of the events because of my client. Like this is, try to link Donald Trump's speech to that guy dying. And you'd have to sue everybody else. Like you'd have to sue the agency for deploying him. You'd have to sue all of the people who are involved in January 6th at any level. Everyone who failed to protect the office for failure to supervise, failure to back up, failure to reinforce. But really, if the allegation is that he was sprayed from less than 8 feet away with a chemical spray, you better show how that chemical spray is known to cause blood clots or has any sort of history of doing that. They shouldn't have any way to do it, but I guess we'll see. That's actually a very quick Trump date on that topic. I have to grab this other story because I completely fucking forgot to send it to me. I probably lost it. I'll have to find it. Trump. Oh yeah. Let me find this. Another update. Michael Cohen is trying to sue, former Trump attorney Michael Cohen is trying to sue Donald Trump. There is an update in his case that we have right here. Pull this up. So the federal appeals court has denied Michael Cohen's attempt to revive the lawsuit against Trump. Michael Cohen told Fox News Digital he'll take his fight to the Supreme Court. Buddy, I'm sure they're just begging. Wait, what the fuck is? God damn it, Fox News. I'm sure they're just begging to take that case of all the Trump stuff. Let's see here. Let's bring this one up instead. It's from Politico. Michael Cohen can't hold Trump liable for retaliatory imprisonment, appeals court says. 3-judge panel concluded Cohen already obtained relief. So Michael Cohen can't hold his former boss, President Donald Trump, liable because he was jailed for what he claimed was retaliation for writing a tell-all memoir, an appeals court said Tuesday. And Holly movie star says maybe it was that special CIA pepper spray. Ooh, says joke, but you're not joking. That's serious. CIA has that secret pepper spray that goes ahead and blood clots people. They sell it to the KGB. The Second U.S. Court of Appeals in Manhattan said in an order that it would not revive a lawsuit that a lower court judge had tossed out because the law did not seem to provide a damages remedy for most claims that someone was jailed in retaliation for their criticisms of a president. That's interesting. There is, of course, a damages remedy that someone being jailed in retaliation for criticism of a president. I mean, there is obviously a deprivation of civil rights claim under the law, whether or not you can bring that against a president, but you'd bring it against the Department of Justice rather than the president. It doesn't, that doesn't make sense. I'd have to read the actual ruling to figure out exactly what they were saying here, because this seems like a weird gloss of the actual issue. 1 second. All right. Damn it. Where the hell did that go? Renogenic. Yeah, Renogenic says, still here. Thank you for the well wishes and prayers. I lost 13 years of no self-harm, no stitches, but that's just a battle. Still in the war. I took your advice after losing 3 to 3 pints of blood, went to the hospital. 66 staples in 1 cut. Shit, brother. I'm glad you went to the hospital. Thank you for listening to that. Please, please, please make sure you have a counselor, a confidant, someone who can help you through those times, man. Do not engage in that type of shit. You got people who depend on you. All right, here we go. A 3-judge panel concluded Cohen already obtained relief by getting a judge to order his release from imprisonment to home confinement several weeks after he was abruptly put behind bars when the government claimed he violated severe restrictions on his public communications. It said the law did not provide an outlet for more relief than that. Okay, so he claims he's got this home confinement. He gets put in prison after they claim he violates an order. He files basically for a writ of habeas corpus saying his civil rights have been violated. He should not be in prison based on this. He gets out. That is the remedy. You would have to show some level of malice, some level of violating going beyond the discretion of a judge so grossly to get to a civil rights violation. And it's funny because Michael Cohen is just experiencing what, everyday criminals experience every day. They get imprisoned or jailed for too long, and it is too long. Don't get me wrong, but I use air quotes because the government never agrees that it's too long. They don't see the problem with taking you away from your life, your family. Now, Michael Cohen isn't going to lose his job at the lumber mill because he was jailed inappropriately and held, beyond the required time period for his release. He won't do that. He's rich and he's famous. So he's going to be able to survive through that. But regular criminals deal with this all the time. Now they are criminals and they're getting some sort of punishment. But when that jailing takes place and it goes beyond what the punishment merits and they go back and correct it, it's like, oh, sorry, bro. Here you go. You're back. You're fine now, right? Like you didn't lose anything from that time gone. Well, I can't get that back. And it kind of runs in conflict with stuff the Supreme Court has said about imprisonment, where they talk about arrest and imprisonment being such a gross infraction or infringement of civil rights that it's almost a priceless remedy. I mean, how much is being taken from your life by the government for even a moment worth? What amount of money can bring back those moments? There's somewhere. Lord of the Kino says, bro, you ever eat buffalo, my man? Buffalo Dan does it good. And then he's got a cat and a fish. Yes, I have eaten buffalo. It's delicious. You should try it. Here we go. We've got Cohen served over a year of a 3-year sentence in federal prison after pleading guilty in 2018 to tax evasion, campaign finance charges, and lying to Congress, saying Trump directed him to arrange the payment of hush money to a porn actress to fend off damage to his 2016 presidential bid. Well, I mean, he pled guilty, 3-year sentence, gets a year. in prison. The problem with Cohen here is, I mean, getting 3 years on home release for this, like, this shit's crazy. Tax evasion, campaign finance charges, and lying to Congress. Okay. Freed early to home confinement as authorities worked to contain the coronavirus outbreak in federal prisons, Cohen was returned to prison weeks later when authorities claimed he failed to accept certain terms of his release. At the time, Cohen said he had merely sought clarification on a condition forbidding him from speaking with the media and publishing his book. After serving 16 days in solitary confinement, fuck that. That Cohen said left him with shortness of breath, severe headaches, and anxiety. He was eventually freed on the orders of a judge who said he'd been jailed in retaliation for his desire to publish a book critical of the president and to discuss it on social media. Cool. Cohen sued Trump and then Attorney General William Barr, along with various prison and probation officials. The statement Tuesday, Cohen said he'll appeal to the U.S. Supreme Court. Good luck, I guess, on that. It's I don't see why the Supreme Court would find this issue interesting enough to grant cert. I mean, the only interesting thing is that it involves Trump and Cohen. So there is this sort of celebrity aspect to it. But what is the relief he wants? He served 16 days in solitary. He didn't like it. No one likes solitary. Solitary is very, very shitty. That's a pretty consistent thing for people to report, is that solitary confinement is hard on people. That's why they do it, right? That is why they do it. But did the government have an adequate ground to go ahead and say that he violated his release conditions? Well, if they're wrong, his relief is to be released. They don't always give you your time back. In fact, some people are in prison for 20, 30 years on a wrongful conviction. They don't get that time back, and they don't get monetary compensation. So I'm not sure what Cohen's legal theory will be. I know that the district court judge found it was done in retaliation. I guess that was not appealed. So cool. But the U.S. Supreme Court may take it up, but I'm just not sure why. Like, what further relief are they going to grant him? Now, we're going to grant you relief, and you're going to get millions of dollars now. Okay. The outcome is wrong if democracy is to prevail. A writ of habeas corpus cannot be the only consequence to stop a rogue president from weaponizing the DOJ from locking up his/her critics in prison because they refused to waive their First Amendment right, he said. Now, this is interesting because technically, he did waive his First Amendment right. In agreeing to his release conditions, in his plea agreement, he waived his First Amendment right. Now, he may say that he didn't violate his First Amendment. Apparently, the judge somewhat agreed with that. He didn't violate his release conditions. But you do have the opportunity to waive portions of your First Amendment right when you make a plea deal that says you won't discuss or talk about something. I hate those, by the way. It's a prior restraint. I think they're coercive. I think they're abusive. I think that they do violate the core tenets of the First Amendment. I do not think that the privilege of not being sent to prison should be conditioned on what you're going to say or not. But hey, I don't make the rules. The rules are you can forfeit portions of your First Amendment right. And people do so every day in plea agreements. They do so every day in various orders. They do so in civil court. They do so in criminal court. This idea that I refuse to forfeit my First Amendment right. Well, no. You actually specifically signed a document where you did give up a part of it, just a part of it, in exchange for not going to prison. And then you allegedly violated it. A judge said you didn't, so you got out. I mean, that's how it goes. And again, every single person who's in the criminal justice system, runs the risk of running into this. You make a plea agreement, you say you're not going to do something. The government thinks you do something, they put you in jail. they arrest you or they humiliate you in some way. They love to do the humiliation part. It's a big part of the whole thing. They do all that. Then they're wrong. Like you get a judge to let you out. But your relief is always being let out. Unless you can show, again, a specific effort with knowledge that they're overstepping, some sort of communication, some sort of message. He didn't do anything, but let's punish this motherfucker. Like if you have a message from Trump doing that, then you've got a smoking gun. Then maybe at that point, you can make that argument. Doesn't seem to have it here. So what other relief are they going to give him? I have no idea. Trump's lawyer, Alina Habba, said in a statement, "We are very pleased with today's ruling. Mr. Cohen's lawsuit was doomed from its inception. We will continue to fight against any frivolous suits aimed at our client." And of course, the entire time Trump is just dumping money into this shit. Just dumping money. And of course, that's all of this stuff. All of this stuff is around causing damage and causing a buzz and a stir around Donald Trump, causing him quote unquote trouble. But I don't think it's working the way they want. And I think Trump is actually kind of happy about how it is working out. There's one more news story I saw about Trump. Let me grab this. Sicknick. Where are we? Fucking hell. There was one more. Oh, that's right. Trump is suing. I gotta find this. Trump sues Maine Secretary of State. This is the other story. Here we go. Sorry about that. Had to get my brain to remember what the headline was because my entire prep time and everything was kind of truncated today, along with the events as to why I have a shorter show. And so I saw the stories I wanted to grab and forgot to send a couple of them. We got it now. Here we go. Donald Trump sues after he was disqualified from Maine ballot, opening new front in insurrection fight. U.S. Supreme Court is already considering whether to hear a similar case out of Colorado that could decide the question of Trump's ability to appear on ballots across the country. Of course, the Supreme Court has to do this. Of course, the Supreme Court has to take up this question. Can a state actually go ahead and remove a president from a ballot under the 14th Amendment? Can they do that? Because if they can do that, we're in insane times. But here we go. Former President Donald Trump sued Maine Secretary of State Tuesday for disqualifying him from the state's primary ballot because of his role in the January 6, 2021 attack on the U.S. Capitol, opening another legal front in the saga over whether voters in some states will be barred from selecting the Republican frontrunner. I saw someone in the chat say suing her in an individual capacity will fail. No, she sued in her capacity as Secretary of State. However, you have to sue the person. You cannot just sue the state. The state has sovereign immunity unless they choose to accept the suit. So what you do is you end up suing a department head. You sue the person responsible for the action of the state in their official capacity. If they lose the suit, the state steps in and has to, provide the compensation. But that's that. So he sued Maine Secretary of State for disqualifying him. Election officials and courts in several states are considering whether Trump's actions on January 6 disqualified him under a Reconstruction era provision of the 14th Amendment, known as the Insurrection Clause. Only two states, Maine and Colorado, have so far decided that Trump should be removed from this year's primary ballots. Now, the Colorado one was done by the Colorado courts. Ultimately, the Colorado Supreme Court has decided that Trump should be removed from the ballot, which seems to be a massive judicial overstep. Also, a federalism problem. States should not have the ability to remove a president. Also, it's just a basic misread of the 14th Amendment and what is plain language of the text. It does not mention It does not mention that a president can be disqualified. And similarly, it does not mention the president as a list of positions that have been formerly held by the accused that have taken a specific oath to support the Constitution. The president does not take an oath to support the Constitution. The president takes an oath to uphold and defend the Constitution, which is distinctly different from all of the other listed positions. The president is not included in the 14th Amendment, and that is the ruling that should come from the Supreme Court if they do this. And the president is not included in either of the two lists, either the list of positions that they can be disqualified from or the list of positions that they had held prior that would allow them to be disqualified from another position. And the reason the president isn't included is pretty obvious. The president is a political figurehead manifesting the will of at least half of the country. If you have one state or one person with the ability to immediately remove the president or a presidential candidate from their legitimacy in holding office, you have a clusterfuck. You have the ability to shut down half of the country's or more political will with one state. And in Trump's case, there is no finding of insurrection outside of the Colorado courtroom, which found by clear and convincing evidence, which is somewhere around a 60% proof standard, 60 to 70% proof standard, that he had engaged in an insurrection, which is insane because what is the insurrection? Can a president even insurrect his own administration? The answer is kind of. In my opinion, the answer would have to follow a successful impeachment. Otherwise, he is a president and you can't really insurrect yourself. He's not rebelling against any government, and the claim that he was interfering in some way with the transition of power is baseless because the transition of power happened on time and under budget. So none of that can actually really happen unless you have an impeachment with removal of the president. Once you have that, then you could subsequently say, okay, he's no longer the president. He did act in a manner that removed him from office. Now we can say he engaged in insurrection. I think without that, you have real trouble. You have logical trouble just applying this. But again, the 14th Amendment doesn't actually include the president in the express language of any of it in either of the two lists, and certainly not with the oath of office. So you've got a problem there. How can you say the founders or the framers of the Reconstruction intended to include the president when they didn't write it down? And they easily could have. They easily could have. So, let's see. They've the decision from Colorado's top courts is so I mentioned that Colorado has done this through the courts. Maine was different. The Secretary of State of Maine determined Trump engaged in insurrection. And the Secretary of State of Maine then kept him off the ballot. There wasn't a court proceeding because the Secretary of State of Maine is empowered to make that decision. They are the adjudicator. They are the judge in that case. Well, the judge in that case is a Democrat operative who is overtly anti-Trump. And, I think he requested her recusal and it never, she didn't recuse herself. So we've got issues there as well. The decision from Colorado's top court has already been appealed to the U.S. Supreme Court. In Maine, the decision was made by the Secretary of State rather than by a court. Trump's first line of appeal is to file a lawsuit in state court challenging that secretary's decision, and that is what he did on Tuesday. Now, this is interesting that he has this, that this would be the first line of appeal to file a lawsuit in state court, when ultimately this is a federalism question. Again, why can a state exert authority over the chief executive, either the former chief executive or a potential new chief executive? How are they able to deprive other states, other voters of the right without some sort of express consideration? Article 3 of the 14th Amendment does not have any enforcement provision, and it doesn't have any way to determine what an insurrection is or to in any way label people insurrectionists. At the time that it was written, it's obviously right after the Civil War, and all of the people on the list made obvious sense and were clearly identifiable, which might be a hint as to another reason why the president wasn't included, because Abraham Lincoln did not insurrect against the United States. They just didn't. So why would they include the president or the vice president of the Union who were still part of the Union? They wouldn't need to. If that's the case, then that clause is a dead clause. The insurrection clause would be dead. And well, theoretically, because what other insurrection would you be able to identify in that way? Trump called the Secretary of State a biased decision maker, of course, in the suit, and said his disqualification was the product of a process infected by bias and pervasive lack of due process. At issue is a provision of the 14th Amendment that bars people from serving as president. Nope. That's not there. Or a member of Congress. No, actually, how fucking wrong can you get? Member of Congress is the only one that's right here, but they left off a whole bunch of other things. But president isn't in the list. If they previously took an oath as an officer of the United States and then engaged in insurrection or rebellion. Wrong. It's an officer of the United States who took an oath to support the Constitution, which Trump did not do. Also, the president is not an officer of the United States. He just isn't. He's the chief executive of the United States, not the chief executive officer of the United States, which is a weird distinction. There's actually Supreme Court precedents that backs up the idea that the president is not included in quote unquote officers under the United States. And it's specifically officers. They say officer of the United States, but I think it's officer under the United States. Let's check it out. I always forget the exact wording. Damn it. Amendment. Can't type here. Let's see. Here we go. No person shall be a senator or representative in Congress or elector of president and vice president or hold any office, civil or military, under the United States or under any state who, having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state. Okay, so it is officer of the United States in the second one. I still don't say that includes the president, but it is different than officer under the United States, so maybe. However, presidents are not included in that first list. I would contend they're not included in either, especially because they have to take an oath specifically to support the Constitution, which the president does not do. And then engaged in insurrection or rebellion, Maine Secretary of State Shanna Bellows, a Democrat, announced she believes the provision applied to Trump. Well, that's just lovely. She believes. Who fucking cares what she believes? Randall McCollum is now a monthly supporter. My Dumb Movie says, you keep saying Trump didn't take an oath to support the Constitution. Please read the presidential oath to us. Half of it is about supporting the Constitution. No, it's not. It's to uphold and defend the Constitution. I'll read it to you if you want. Presidential oath. We did this the other day, but let's just do it. I do solemnly swear or affirm that I will faithfully execute the office of President of the United States and will, to the best of my ability, preserve, protect, and defend the Constitution of the United States. Now, what does the congressional oath of office say? I do solemnly swear or affirm that I will support and defend the Constitution of the United States against all enemies, foreign and domestic. It's weird that support is specifically in all of the other oaths and not the president, and yet they chose to include support in the 14th Amendment. Why? If you say that it's about supporting the Constitution, I mean, you can argue that it's about whatever, but they used a specific word. Now, if you're not sure how constitutional analysis goes under the court's, process, when language is clear and unambiguous, it is presumed that the words put down by Congress, especially in an amendment that's heavily debated and then, approved by Congress and ratified by the states, it is presumed that every word in there was specifically chosen and that no words that aren't in there are supposed to be in there. You don't get to add words to it, and you don't get to decide that a word is actually another word unless the word is vague on its face. This isn't vague. Support is clearly a part of the oath of office of senators, of congressmen, of everybody else on the list, just not the president. Why would they use that while also excluding the president from all the lists? They specifically list member of Congress, senator, elector of president, elector of vice president, and then what? Well, the president's just included in the officers. Really? Really? We're supposed to believe that everybody else is listed specifically, but not the president and vice president of the United States. To uniquely political offices. To uniquely political offices that span the entire country where none of the others do. By the way, all of the others are localized elections. Senators are elected by their states, right? You get 2 of them. And then congressmen are elected by districts in their states. You get however many are part of your state. Removal of a congressman or a senator or an elector or, getting to officers and officials is a little bit different, but those elected positions that I just mentioned, any of those are localized. If one of those persons is disqualified, it only affects that state. The president and the vice president would affect the entire nation. This is a way, way different category than any of that. And that needs to be considered, but it just isn't. So I'm really interested to see how the arguments go on this. Because these would be hammered to death if I had anything to do with it, because let's just go to the damn language of the amendment. It doesn't include the president. It obviously doesn't. And there's so many good reasons to not do it. Having the ability to kneecap the political will of half the country with a bogus charge, a bogus conviction, a determination by a court, runs afoul of every other thing we know about the separation of powers. It's specifically what justices have tried to avoid. The Supreme Court justices have tried to avoid the entire time. My Dumb Movie says the definition of uphold is to confirm or support. Great. Why didn't they write support? And then why did they write support? You can make the claim that it means support, but it says support. And why do you get to decide that support means something other than support? Sorry, buddy. Go for it. It's, again, the idea. We have so many of these types of provisions. It's why congressmen cannot be arrested while in session, right? They're on the way to the Capitol building. They run over a bunch of school children. They're going to a vote. They can't be arrested for running over the school children. They have to be allowed to go to session. It's a special privilege that congressmen get. Why is that? Oh, because if you could levy bogus charges against a congressman to prevent them from being at the vote while Congress was in session, you could exert political will unduly over the country, preventing a vote by utilizing a legal process, maybe in a state that didn't want a certain congressman to get there, is so powerful that they gave them immunity from all arrest for any crimes on the way in to session. Again, the idea of utilizing a branch of government or an act of government to kneecap the political will of the people or of the representatives or of the states is afoul of the Constitution. And having Trump or anyone who's running for president or vice president be removed from a ballot simply because a secretary of state or a state court has determined that they did something that no one else has determined, that has not been tried, that is actually a criminal charge, that they did that, and then therefore they can't be on the ballot. Like that's a massive, massive statement. and the amount of power that would give states, especially Secretary of States who are political animals, especially state courts who shouldn't have any jurisdiction over the president at all for any act in office. I mean, these are basic separation of powers issues, and trying to just say, well, of course they can. Well, why of course? And that's a fundamental question everyone misses. Why is it of course? All right, here we go. I just got tea in my eye. Bellows put the effect of her decision on hold pending resolution of the issue in the courts. The evidence, she said, demonstrates that the insurrection occurred at the behest of and with the knowledge of and support of the outgoing president. Again, how can you insurrect yourself? The Constitution, she wrote, does not tolerate an assault on the foundations of our government. It actually does. There is a treason provision in there, by the way, and Trump has not been charged with treason either. Bellows denied her decision was based on personal political views, telling CNN last week, no Secretary of State has ever deprived a presidential candidate of ballot access, but no presidential candidate has ever engaged in insurrection, which is almost decidedly false when you can just decide what insurrection is. But there we go. That's the Trumpdate. That's the fun issue you have there. Leon's Law says your favorite constitutional lawyer must be Pisco. Was talking shit on Destiny's stream. Got to run. I've got mediation tomorrow. Love you, homie. Yeah, that's probably because I dumped all over him the other day. He deserved it. That dog in M says, can I get a toast for my brother who died after eating a Popeye's biscuit with no drink? Because I quote, I'm a real one. Cheers to your brother being the bravest soul on the planet, eating that dry but delicious fake buttery biscuit with not a single drink in sight. May his asphyxiation carry him to the halls of Elysium. All right, here we go. We're going to go ahead and move on to the last subject. Again, short show tonight. I do want to talk about this. This is pretty wild. Big topic in the aftermath of overturning Roe versus Wade. Hey, what's up, Steph? Happy New Year to you as well. Here we go. This is the appeals court rules. Texas can ban emergency abortions in spite of federal guidance. The Biden administration had appealed a district judge's ruling that sided with Texas Attorney General Ken Paxton. What the Hold on. That was weird. Is this a video? God, I don't want a fucking video. Oh, God, this is a video. Let me get a better... I don't want to support your shit by allowing ads. I want it to go away. I just wanted an article. Okay. We'll just grab it from a different place. From the Texas Tribune. Oh, they hate this stuff. This will be fantastic. Geg says, please pursue this Trumpdate throughout 2024. Thank you. Well, it's going to happen. It's going to be major fucking news every time. Yes. China says, how many times have you looked at the bottles at your feet? 0. Emergency rooms not required to perform life-saving abortions, federal appeals court rules. Well, that's fun, isn't it? Biden administration reminded hospitals of their obligation to perform life-saving abortions under the Emergency Medical Treatment Labor Act after the overturn of Roe versus Wade. Texas sued, arguing it was an overstep that mandated abortions. And here is the interesting question, right? Here's the interesting question. Now, you have to step aside from your personal moral beliefs or convictions about abortion or about where it belongs and realize that this is a legal question. This is a legal question. The legal question is, do states have the right to restrict abortion, or do federal governments? Let's change that up. Do states have the right to restrict medical care within the state, or does the federal government have the power to require states to allow certain medical care within the state? That's the question. And right now, after the overturning of Roe versus Wade, It kind of looks like the states do. And I'm not sure where the federal government has any ability to say anything on this absent an amendment. Because why would they? This is completely inside the state. The state has the police authority to regulate medical care, medical decisions. They always have. States can prevent end-of-life care from happening. For example, the federal government can't just make a law that says, oh, states have to allow people to have assisted suicide. None of that exists anywhere else. Why would it exist here? The reason why it would exist here is because abortion is the sacred cow of liberalism. It is. It's been there forever. It's been, since Roe versus Wade, and it's been a primary issue since then. And since it's been that way for so long, they can't fathom the idea that the state could do something different. But Roe versus Wade did not recognize a right to or right to medical privacy or any of this bullshit that they talk about. Briefly, Roe versus Wade created a special sacred protection for abortion procedures that far outstripped literally any other right from the Constitution. Any right in the Constitution, put it up against Roe versus Wade. You don't have a fucking prayer of being more protected in your right to free speech, assembly, redress of grievances. You don't have anywhere near this right in the Second Amendment, Fourth Amendment, Fifth, Sixth, Seventh, Eighth, Ninth, none of it, not even close. There is no freedom in the Constitution that rivaled abortion. Abortion was created by a political decision of judges at a particular time based on lies and misrepresentations and misunderstanding of science. And that magical miasma created the idea that women needed this special thing. And they justified it with bullshit that is completely fictional about every other medical procedure, medicine, protection, provision that exists. Nothing else got the treatment. Ask any man if anything he's ever said to a doctor has been protected as hard as a woman who wanted to kill her baby in utero. Nothing at all has ever been that protected. But they act like, oh yeah, well, of course you have medical autonomy. Oh, do you? Do you? Prescribe yourself some opiates. Why don't you just go, again, buy Sudafed? Oh, you go on a list? You go on a list when you get an abortion? No, only if you want to. They can't put you on a list. They can't do this obstructive and intrusive thing. Can they force you to do an ultrasound? On the over the stomach? Yes. Transvaginal ultrasound? I don't know. It's very invasive. Ignore the fact that a transvaginal ultrasound is a common procedure that is minimally invasive, but a D&E involves shoving glass rods into the cervix to dilate it and then a vacuum cleaner to suck out a baby. Like, just ignore what will happen if they're doing an abortion. That transvaginal ultrasound, that's the violation. Like, this is a sacred cow. It was created as a sacred cow. It was treated this way forever. Of course it was. It was part of the core agenda. Kill the undesirable population, reduce population growth, build good little servants, reduce the value of family, reduce everything. Oh, and specifically get rid of those blacks. Federal regulation do not require emergency rooms to perform life-saving abortions if it would run afoul of state law, a federal appeals court ruled Tuesday. There you go. Matt Murphy says, American women be lazy. Mexican women cross the desert. Chinese women cross ocean to secure citizenship. American women won't go to the blue state next door to ensure continued wanton behavior on half-price margarita night. Damn. After the overturn of Roe versus Wade in June 2022, U.S. Department of Health and Human Services sent hospitals guidance, reminding them of their obligation to offer stabilizing care, including medically necessary abortions, under the Emergency Medical Treatment and Labor Act. When a state law prohibits abortion and does not include an exception for the life of the pregnant person, or draws the exception more narrowly than EMTALA's emergency medical condition definition, that state is preempted, the guidance said. Fifth Circuit disagrees. And the question on preemption is, why would the federal government have the ability to preempt state law here? Why would they? Now, there's a second question, right? The second question is, what jury convicts a doctor for saving a mother's life by doing a medically necessary abortion? this is the balance. I don't think a jury does that. Maybe I'm crazy. Maybe I'm naive. I just don't see a jury going, you know what? Yeah, put him in prison or whatever. Like, I don't see that happening, but who knows? Texas sued, saying this was tantamount to a nationwide mandate that every hospital emergency room physician perform abortions, because it is. Several anti-abortion medical associations joined the lawsuit as well. Now, importantly, you may think that that's the right thing to do. And I'm maybe there. Like, I'm maybe thinking that hospitals should perform that life-saving care. It's a really, like, that's a sensitive subject, because I'm overtly pro-life in almost all situations. I can't think of many where I'm not, but that one is tough, where it's like, at this point, like, what life? It's also really rare to see a medically necessary abortion in this capacity, but they do happen. They're so rare. And of course, the propensity would be to just say everything is medically necessary for the life of the mother when you're justifying an abortion. That's the concern. But it's a tough one. This isn't about that, though. It's not about what's right. If you don't like what Texas is doing, go anywhere else. For your abortion, move out, whatever it is. Right? Like, that's what every other legal policy we have. You don't like taxes, move to a different state. You don't like this, move to a different state. You don't like the gun laws here, move to a different state. Or you fix it, like you lobby and try and get it fixed. But since summer of 2022, all abortions have been banned in Texas except to save the life of the pregnant patient. Wait a minute. So wait, there is an emergency provision here, but doctors and their patients with medically complex pregnancies have struggled with implementing the medical exception, reportedly delaying or denying abortion care rather than risk up to life in prison and the loss of their license. And again, trying to find the jury that would convict and do this is something, especially when there is a provision in law that says except to save the life of the pregnant patient. Now, why have they struggled this, though? Let's just go ahead and talk about why they've struggled with this. It almost never occurs. I can't stress this enough. It almost never occurs. It's uncomfortable for people because they hear it occurs all the time, but it really almost never does. The solution most of the time for what is quote unquote medically necessary abortion would be to perform an abortion by cesarean and deliver the baby early. And the baby may be very premature and very much at risk, but an effort can be made to save the baby. It is rare that a medically necessary abortion to save the life of the mother occurs prior to that 20-week number. It's very rare. And this is why these Texas hospitals are having such trouble implementing it. Because what actually is necessary to save the life of the mother, that requires the termination of the baby, not just the termination of the pregnancy. Because an early delivery cesarean is an abortion. It's an end of the pregnancy. It is the stoppage of the process. But that doesn't necessarily have to involve the termination of the unborn child. So having these things occur that early, very, very rare. Now, they do happen, but where? And again, this is probably why Texas is having so much trouble with it and other states. Jesse Bear 2115 says, abortion is defined as intentionally killing a fetus. Baby unintentionally dying while saving the mother isn't an abortion. Again, that's if they make any reasonable effort to deliver the fetus. Again, a cesarean or an induced delivery. These things are potential solutions. And of course, you can't just blanket say everything is fine. There's always oddities in medical reality, but it's man, it's just not common. The Squid says, aren't hospitals already required to provide life-saving care in the emergency rooms? So why is abortion specifically mentioned? Plus, most pregnant women are informed well in advance if their pregnancy is at risk. Yeah. But the reality is people want abortions. They're looking for an excuse. I hate to put it that way, Drop Barracuda says, just realize that since Texas has an allowance for rape victims, I foresee many, many false claims in order to get one, which is the problem with the rape victim allowance. I don't know how you get around it because you definitely don't want to. I say definitely. Some people definitely don't want to force women who are victims of rape to carry the baby to term. But at the same time, you can't verify it. And then it does result in false accusations. Zachary Keith Hasbrook says, can't be pro-life if you aren't a vegan. Checkmate. Well, dude, Zachary, if I eat vegetables, then you're on the chopping block, brother. At a hearing in November, a lawyer for the U.S. Department of Justice said that while Texas law might not prohibit medically necessary abortions, the guidance was intended to ensure that the care is offered when it is required under the statute. Individuals are presenting to emergency rooms suffering from these emergency medical conditions. McKay Neumeister said, yeah, very unlikely. Right now, HHS can't ensure that the hospitals are following their obligations and offering the care that's required. In August 2022, a federal district judge in Lubbock agreed with Texas, saying this guidance amounted to a new interpretation of EMTALA and granted a temporary injunction that was later extended. The Fifth Circuit heard arguments in November, and the judges seemed prepared to uphold the injunction. Judge Leslie Southwick said there were several extraordinary things, it seems to me, about this guidance, and said it seemed HHS was trying to use EMTALA to expand abortion access in Texas to include broader categories of things, mental health, or whatever else HHS would say an abortion is required for. Exactly. This is it. The life of the mother is a nebulous and spongy thing. And if you open the door a millimeter, they will take it for a kilometer. I don't know, they're Euro cucks. Who knows? Fire PA says this also specifically regarding emergency departments. Wouldn't most of these individuals be admitted to an inpatient unit and offered the procedure anyhow? Probably not in Texas, but maybe. Tuesday's ruling, authored by Judge Kurt D. Engelhardt, said the court declined to expand the scope of EMTALA. We agree with the district court that EMTALA does not provide an unqualified right for the pregnant mother to abort her child. Engelhardt wrote, EMTALA does not mandate medical treatments, let alone abortion care, nor does it preempt Texas law. So this will be going potentially to the Supreme Court. What we have to have is a circuit split somewhere, probably before the Supreme Court will go ahead and jump into the issue. Right now, they can let the issue stand and let the words of the statute stand on their own. Congress is free to try and change it, and that could change the entire calculus. But they just right now have guidance from HHS that says it. There isn't wording in the law that attempts to preempt state law. And if you don't have a conflict because Texas allows for emergency medical care, which they do, their law allows for it, that hospitals find it difficult to implement doesn't mean that their law is actually in conflict with this federal guidance anyway. But the question is, what are the cases that are coming in? How are they medically necessary for the life of the mother? Is it really about other factors than actual imminent threat of death? And the answer is almost always yes. Finding cases where mothers are at risk of dying to the point where an abortion rather than a delivery occurs is exceedingly rare. It just is. Stats back that up pretty heavily. And the fact that they can't ever cite a case where you go, oh, she would have actually died in, within an hour or two. She doesn't get this care. She would have died within the day. That doesn't happen very often. We're getting pretty damn good at this. It also generally doesn't happen that early in the term. So, So there we go. Ladies and gentlemen, that's actually the show for the night. I said it was going to be a short show, between 60 and 90 minutes. And we've gotten all the chats that have come in. We're going to go ahead, or wait, I think. Oh, wait, we got one more on Rumble. Snuggle Struggle says, Rackets, you had mentioned a conversation with Destiny the other night. Could you tell me which creator hosted anything so I might watch later? Oh, a conversation I had with Destiny? No, I had a conversation with other lawyers on Destiny's channel. This would have been back in 2022 sometime. It was not recent. It was about abortion as an issue. It'd be somewhere on Destiny's stuff. I don't know. Low Watermark says, I really like the energy and flow tonight's show. 2024 looks good if this is where you're going. Well, we'll see. we'll see how the month progresses. Again, I didn't want to do a short show tonight, but some shit came up. Need to go ahead and deal with life as it happens. We will be back for a full show tomorrow. Should be anyway, outside of some unforeseen event. And again, the rest of the week, it seems extremely likely that I will not be doing a show on Friday. And I will not be doing locals tonight, but we'll try and squeeze an extra local stream in somewhere. I will let you know as that develops. Sorry to bail on y'all early tonight, but thank you for coming. So many people watching. It's really great to see. We will catch you next time. Have a good night. Peace. Peace.
Oh, he drinks a fair bit, but you realize that it just helps get his noggin jogging along. With his glass by his side and his kids asleep tight, we'll hear some lost-plaining tonight. With his microphone muted, we'll laugh at this boomer until he explains it's all part of the plan. Watch his face become redder as he becomes meta, raging at idiots from Twitterland. From the white shores of Maine to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, his lady is fair, and she handles herself with the grace of one who has borne many children. As the wife of a lawman, she makes sure that he has the time and the place to provide for them there. So pour out an ardbeg, a bow, more of that brook. The spirits blow as the ones who get unemployed. So pour out a glass for the tea post on Twitter, as we hear lost-plaining tonight. From the white shores of Nairn to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, the guests are all plenty folks, from Doug T to Drexel. They bring their perspective and spice to the mix. But the reason we're here and the one that we cheer is the one who is showcasing us his career. Get unemployed. So pour out a glass for the tea post on Twitter, as we hear lost-plaining tonight. From the white shores of Nairn to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law